trying to determine here is whether a foreign subsidiary of a U.S. corporation can be subject to general personal jurisdiction in North Carolina on claims which are not related to the subsidiary's activities in the state of North Carolina. Elizabeth, you never looked that bored.
Oh, I'm sorry.
I'm just teasing you. I was like, she looks so bored today. You stare at the people that are in the front. All right, so if you're counsel, Attorney Belanki, and by the way, I love your last name. I've never seen it before, and I think it's awesome. It's kind of like Beyonce named her mom named her maiden name, like Belanki is like a cool guy name, like not a last, I mean, it's still a cool last name, but I like it, it's cool. All right, so I may borrow it one day. So Belanki, Attorney Belanki, if you're the counsel for the subsidiaries, what's your argument as why there should not be personal jurisdiction, not in New Jersey, but in North Carolina?
There's no specific jurisdiction.
Why? Put your international shoe hat on. Why not?
Not enough minimum contacts.
Okay, and what facts tell you that?
The boy's accident happened in Paris, and then this is a separate jurisdiction. And the defective tire was manufactured in Turkey, so North Carolina doesn't have anything to do with it.
Okay, so I need you specifically to tell me why there shouldn't be personal jurisdiction using the facts of the case, more factual. What are their contacts? What contacts do they not have with the state of North Carolina? So if you're trying to make the argument that there's no personal jurisdiction, you're trying to establish that they don't have any contact with that state, right? So what facts support that?
I'm not sure.
Who's buzzing?
Sorry, that wasn't mine.
I'm so glad it wasn't mine. I learned to put my stuff on an airplane, as you all remember early in the semester, because if they're on your favorite list, you have them on Do Not Disturb, they still blow your phone up in class, so I figured that out the hard way. I have to ask Attorney Belanki, did you regular brief or book brief, because you're a second semester rising 2L, soon to be?
I read this like last week, and I kind of read it again, like,
A refresher?
But, I'm not too strong at it right now.
Okay, but I'm saying, did you book brief, or do you have a brief? If I walk up there, do you have a brief, or did you just take notes in your book?
I don't like completely brief like that. I kind of follow through along the case.
Okay, so when you don't brief like that, it creates these kind of challenges. So I really want you to do well in the class, not just because I like your name. So I'm gonna call on you probably again tomorrow, just to make sure that you are studying in a way that's gonna make sure you not only pass, but do very well. Just I'm giving you a heads up ahead of time. Attorney Jarnigan, can you help me out with that?
It's because they manufactured everything overseas, and they didn't sell anything to North Carolina or manufacture, or the subsidiaries didn't have plants or anything.
Absolutely, so they have no plants there, no offices there, sounding like International Shoe, right? No bank accounts in North Carolina. They're saying, look, we should not have, North Carolina should not have personal jurisdiction over us. They don't design, manufacture there, they don't advertise any products there, nor, which is very important, do they sell or ship any any products to North Carolina. So although a small amount of their tires were distributed by Goodyear USA for special custom fit vehicles, the type of tire at issue here was never distributed in North Carolina. So before we move on, just in general, does that fact alone sway you all, regardless of what the court said? That specific tire that's the source of the lawsuit was not the type of tire that was in North Carolina. Should that matter? Anybody think that should matter? Or no, it's just one of your tires. It doesn't have to be that specific kind. Yes, ma'am.
Just because it's not there now or hasn't been in the past doesn't mean it won't be there in the future.
So you don't think you should hold me accountable when it's actually there in the future?
I think that, but
There's no right or wrong answer. It's just your opinion.
I think that it's like back to the stream of commerce. So any tire you make could potentially end up anywhere at any time.
Ooh. So are you our foreseeability alone advocate of,
I don't know.
okay. It's like, where do you stand in that, yes?
Let me try to understand what the question is. There's the fact that they don't make, that specific tire that was involved in the accident hasn't ended up in North
Has
Carolina.
never
at any
been
point.
distributed in North
You're
Carolina.
asking if that should be relevant to this particular case at all.
Yeah.
Part of me wants to say yes, but part of me also wants to say no, because because specific jurisdiction arises out of, like, incidents involving contacts with the state. So if you read it very, very narrowly, then yeah, it would matter. But if you're going for something broader, then no, it wouldn't matter. There's still at least been some contact in the past, not smacking continuous for specific, but there's still been contact.
So even though there's contact, don't you feel like, is it fair to bring a lawsuit against them about a tire? You know, the Goodyear 360 that never even got to their state?
Probably not, because,
Yeah, you switched, I noted.
well, I mean, it depends on how somebody reads the case and how narrow they want to define.
It should be
specific
how narrow you
jurisdiction.
define it. Is it fair? And you're not sure.
I'm not.
And that's okay, Elizabeth. I'm not either.
I think holding them accountable for that specific tire would blur the lines too much, like the court is saying, between specific jurisdiction and general jurisdiction. So, you know, it says that, serving to bolster the exercise of specific jurisdiction do not warrant a determination that, based on those ties, the forum has general jurisdiction.
No, you said it correctly. Is that what you were gonna say?
No, I was actually gonna say I
Excellent,
think they
Felicia.
should,
Uh-huh.
because if you manufacture multiple types of tires and this tire's defective, let's say the rest of them aren't, and I'd rather the court be able to step in and be like, you guys need to step your game up before
Yeah.
somebody gets hurt with tires that are actually coming in North Carolina.
Better quality. Curiosity's killing me, so you guys obviously are cool with each other, like you don't dislike each other because you're sitting by her. Sharing a book?
Mhm.
See, I could never do that in law school. How do you do that with your reading schedule?
Oh, we have, yeah, like we each have books.
Oh,
This
so
is
you
just,
do have
yeah.
books.
Yeah, we just switch
Well, I
off
had
reading
friends
books.
in law school that actually shared one book, and they
Oh.
would just like have certain
No.
days.
No.
No, I'm serious.
Sometimes you gotta do what you gotta
The
do.
books are
Yeah,
expensive.
we just switch off these
I might have to find a
Okay.
pole
My
next
back
month.
paid for the grip, like.
All right, I got it. I think it's cool. I was just curious. All right, so we know that what the court basically does here, which we like, is they school us essentially, right? They give us a history lesson of all the jurisdictional. Now you messed me up, Elizabeth. Of all the general jurisdiction cases, starting with the Perkins case and the Helicopterus case, which I don't have you read the whole case. It's all discussed at the bottom of page 134 of this opinion. And so the Helicopterus case that they discuss at the bottom of page 134 stands for the idea that mere purchases by the defendant in the forum state alone, even if occurring in regular intervals, are not enough for general jurisdiction, right? Because you need substantial contact, so not enough. Mere purchases, even if occurring at regular intervals, is not enough, is what the Helicopterus case has said. In that particular case, the defendant bought more than $4 million worth of helicopters from a Texas company with basically for its transportation services. So they said that's not enough to establish substantial contacts. The court also, as I mentioned, discusses the Perkins case on that same page on 134. And basically in that case, the court found that even though a corporation may not have its principal place of business in a state or be incorporated in that state, where the business has substantial contacts with the state, such as running their entire operations in the state, that's enough for general jurisdiction. So before the Perkins case, you basically only had one way of establishing general jurisdiction. It was where the corporation's principal place of business was or where they were incorporated. And that case, the Perkins case, is very significant because that's really the first time they're saying, look, even if they don't have their principal place of business here, even if they're not incorporated here, if they have substantial contacts in Kentucky, you can't assert general jurisdiction over them. So for exam purposes, you should remember the legal principles from both the Perkins case and the Helicopterus case. They're both general jurisdiction cases. And if there's a general jurisdiction issue on the exam, you should mention not only the principal from Goodyear, but also the principal from these two cases. So I'll repeat them one last time in case you didn't think they were important to write down. The Helicopters case stands for the idea that mere purchases by the defendant in the forum state alone, even if occurring at regular intervals, are not enough for jurisdiction. So again, in the Perkins case, mere purchases by the defendant in the forum state alone, even if occurring at regular intervals, are not enough for general jurisdiction. So if I ask you a fact pattern and say, what would the Helicopters court rule, you're gonna remember that and you're gonna apply that to that little paragraph and you're gonna pick B. Alright. Perkins case, again, even though a corporation may not have their principal place of business or be incorporated in that state, there is general jurisdiction where they have substantial contacts with that state. Right? Basically, it's enough to have substantial contacts even if you don't have your principal place of business there and if you're not incorporated there. All right, so important question. Attorney Jarnigan, why is this Goodyear case a general jurisdiction and not a specific jurisdiction case? What's the first prompt? Take your time, because you're doing a great job with a specific jurisdiction case.
Because it has to do with, the defendant's, activities within the state, and whether they're continuous and systematic, would be substantial.
Absolutely, so you correctly stated the law, so you get a high five for that. Can you apply it to this case? Why are those not applicable here?
Because the actual incident didn't occur in North Carolina.
Excellent. Happened in,
It happened in France.
and did you remember that from the reading or from my story?
Your story.
Thank you. Brownie points. All right, so because the episode that we're discussing, the bus accident happened in France, right? Remember, with specific jurisdiction, the cause of action has to arise out of the non-resident defendant's contacts with the state. This bus accident happened in France, and the tire alleged to have caused the accident, again, was manufactured and sold abroad. So North Carolina courts lack specific jurisdiction to adjudicate this controversy, so that's why we're like, all right, we can't do specific jurisdiction, let's see if general will fit. So we know that this is a unanimous decision written by Justice Ruth Ginsburg. What did the court ultimately say, Attorney Belanti? What was the holding and rationale?
The connection is too limited for general jurisdiction.
Excellent. What else do you have for me?
The defendant's connection to North Carolina falls far short of the continuous and systematic general business contacts necessary to empower North Carolina with jurisdiction.
Excellent. So they made a nice comeback too. They made a reference to the Perkins case, right? And said in the rationale, Justice Ginsburg, she said, you know what, this is different than the defendants in that Perkins case, whose sole wartime business activity was conducted in Ohio. The defendant subsidiaries in this case were in no sense at home in North Carolina. And as Attorney Belanti said, they said, look, their contacts with North Carolina are just they're too shallow, right? And it's not enough contacts necessary to empower North Carolina, as Attorney Belanti said, to entertain a suit against them on claims unrelated to the state of North Carolina. So, Attorney Belanti, what does the court say about the stream of commerce and general jurisdiction? What does the court say about stream of commerce and general jurisdiction? So we're supposed to wait on you to read the book because you didn't read to find the answer, essentially. Can you help them, co-counsel?
Well, they basically said, because one of the plaintiff's arguments was that, the tire had reached North Carolina through the stream of commerce, but the court said that that wasn't enough to establish general jurisdiction.
Excellent, great job. Yes, and we'll see whether or not you agree with this. Okay, so I'm just gonna say it louder for the colleagues on the right side or your left. So we know the court says, no, we disagree, right, with North Carolina Court of Appeals that this is a stream of commerce case because some of the tires abroad happen to reach North Carolina, right? They said placing goods in the stream of commerce can bolster the argument that there's specific jurisdiction, but does not necessarily mean there will be general jurisdiction based on the placement of goods in the stream of commerce, because the standard for general jurisdiction is very high. Remember, you have to have substantial context. So just because a few products happen to get in a state, that doesn't meet the bar for general jurisdiction, the court is saying. You have to have substantial context. The court goes on to say that North Carolina court got caught up in this stream of commerce analysis and failed to distinguish appropriately between general jurisdiction and specific jurisdiction. So they said that was the wrong emphasis in this case. So we know the court's ultimate holding is that they reverse the judgment of the North Carolina Court of Appeals and says no personal jurisdiction. So we know the ultimate holding in this case, no personal jurisdiction. Again, not enough contacts with the state of North Carolina, which I agree, not enough to establish general jurisdiction. You gotta have substantial contacts. So the legal principle that's really important for you all to remember from Goodyear is that the court holds that in order for general jurisdiction to exist over a foreign corporation, the corporation's contacts with the state must be constant and pervasive so as to render the corporation essentially at home in the forum state. So again, the legal principle from Goodyear is the court holds that in order for general jurisdiction to exist over a foreign corporation, so in order for general jurisdiction to exist over a foreign corporation, I'm slowing down for the people that are writing, I forgot, the corporation's contacts with the state must be constant and pervasive, so as to render the corporation essentially at home in the forum state. So notice they said the contacts must be constant and pervasive. That's a higher standard than systematic and continuous. Pervasive is a much stronger, a much higher bar, right? So it's important again to remember from Goodyear as well that you don't have to be incorporated in the state or have your principal place of business in the state to be at home in that state. Okay, it's a reminder that you don't have to have your principal place of business there or be incorporated in that state to be considered at home. You just have to have substantial contacts with the state. We like that. So Goodyear certainly means that shipping products through the stream of commerce into the forum cannot constitute substantial and continuous contact to justify general personal jurisdiction. So, yes ma'am, go ahead, you're good.
Oh, well.
No, your
I won't
timing's
say
good,
that,
it's
but
okay.
Do you still have, with substantial contacts, do you still have to do foreseeability and fairness?
No, not at all. So the
Okay.
foreseeability and fairness just applies, an excellent question, I'm glad you asked it, to specific jurisdiction.
Okay.
Great question. All right, so now things are gonna get a little dicey, yes.
So with this case, the takeaway is that the stream of commerce is not enough to establish general jurisdiction, and that in order for a foreign court, it has to be rendered at home.
Yeah, so yes, what you just said is correct about the stream of commerce, but it's important to note that it applies to everything. So just in general, for general jurisdiction, you don't need to have your principal place of business there. You don't have to be incorporated there. You just have to have enough substantial contacts to be considered at home. So regardless if it's stream of commerce or whatever. Okay, so the Daimler case, which I'm excited about. Yeah, we've got time to do it. The Daimler case I like because it's 2014. Like, we like this. This is a recent case. It's not old. Not as old as it could be. And it's very controversial in the fields, and we'll talk about why. So this is the most recent Supreme Court case to address general jurisdiction. And again, 2014 case, another unanimous decision in which Ruth Ginsburg, Justice Ginsburg, delivers the opinion. I love when they actually all agree on, like, that's so wonderful. I wish they could always just all agree, like, this is the correct interpretation of the law. Because then there'd be hope for Congress, right? And my husband said, don't try the jokes, they always bomb. I'm going to tell him I got at least 3 laughs today. So he swears I'm not funny. I was like, I think I am. All right, so the facts in this case, Attorney Belanki.
The plaintiffs, Bauman, filed a suit in U.S. District Court for the Northern District of California against the defendant, Daimler, alleging that MB Argentina collaborated with Argentinian state security forces
Okay.
to kidnap, detain, torture, and kill plaintiffs and their relatives during the military dictatorship that happened in 1976 through 1983, a period known as Argentina's Dirty War.
All right, their dirty war. Thank you. Great job. Okay, so we know the facts. I'm going to make them a little bit more bare bones, just stuff that I want you all to focus on. Plaintiff sues Daimler Chrysler, right? A German parent corporation in federal court in California. Okay, so again, Chrysler sues a German company in California. The plaintiffs allege they were injured in Argentina during the, as Attorney Belanki said, Dirty War, which was from 1976 to 1983. By actions taken by Daimler's subsidiaries, so a parent company in Argentina. Does this make you think if you ever do your own business, you don't want a parent company getting you in trouble for stuff? I think about it every time I see this case. So the issue in this case is whether a foreign corporation, which again is Daimler, right, may be subject to general jurisdiction in California based on the actions of one of its subsidiaries in the U.S. That's deep. So essentially what they're saying, how should we rule on if you do business here in the U.S. with a parent company and something happens, you're going to have to come here and defend yourself if there's a lawsuit. That's essentially what's going on. So think about the politics behind what I just said. If you're a foreign company doing business in the U.S. with a parent company, if something happens with that parent company, we want to go after the big kahunga. If you want to do business here, we're going to hold you responsible via general jurisdiction, meaning we're going to assert jurisdiction over you based on your actions of your parent company. So that's why this is a very politically charged case, right? So how do the plaintiffs go about this, attempting to establish jurisdiction? So Attorney Belanki, where are they incorporated?
Who is?
Daimler, just say that again?
Germany.
Germany. Yeah, you're okay.
Sorry.
It's just a voice. I was looking for it to come from this way, and I was like, well, where are you? All right, and principal place of business is where? Attorney Belanki.
Daimler's, who's principal place?
Mercedes-Benz USA. Thank you for asking.
Delaware?
Yep, so they're incorporated in Delaware, right? Where's their principal place of business?
New Jersey?
Excellent. New Jersey, principal place of business. Awesome. And again, we know they're a U.S. subsidiary of Daimler. All right. Let's go. Awesome. Okay. So, how do the plaintiffs go about establishing Attorney Jarnigan, or trying to establish, rather, jurisdiction here, personal jurisdiction, general?
Well, MBUSA has multiple California-based facilities, and so they say that MBUSA should be treated as Daimler's agent for jurisdictional purposes.
Excellent. So they kind of start relying in this case on agency theory, and they have whole classes on agency law that essentially, under what circumstances are you vicariously liable, like for the act of an employee? When are you liable for an act of a subsidiary or an agent? Someone that you serve as an agent for. So they argue, as Attorney Jarnigan said, that general jurisdiction is indeed appropriate against the Daimler Corporation because they have, again, this U.S. subsidiary. They're incorporated, meaning the U.S. subsidiary, Mercedes-Benz USA is incorporated in Delaware, has its principal place of business in New Jersey, and the company distributes Daimler manufactured cars from Germany to independent dealerships in the U.S., including California. Another part of the plaintiff's argument, as Attorney Jarnigan was saying, was about agency, as I just mentioned, that Mercedes-Benz USA, the subsidiary, is the agent of the parent company, so they're acting on behalf of the parent company, meaning Daimler. And therefore, the actions of the subsidiary can be imputed to the parent. So that's the agency theory. Like if you're a subsidiary, if you work for me, whatever actions you're doing are on my behalf as well. I'm profiting, and so I'm going to be responsible for those actions as your agent, right? And so that's how the plaintiff tried to establish jurisdiction here. Why is this a general jurisdiction case, Attorney Belanki, and not a specific jurisdiction case? That's easy.
Because it's like not substantial enough.
So what's the criteria for establishing specific jurisdiction? What do we look for that I went over at the beginning of class?
The principal activity has to take place there.
Okay, so what do you mean by principal activity? You're close.
In this case, California isn't where the thing happened. It's in Argentina.
High five, perfect, yes. So this is not a specific jurisdiction case because the plaintiffs were injured in Argentina, but they're trying to bring the lawsuit in California. Remember, as Attorney Belanki just said, for specific jurisdiction, the cause of action has to arise out of the defendant's contact with that state, which would be California. This accident didn't happen in California, it happened in Argentina. The claim, meaning the injury in Argentina, has nothing to do with Mercedes-Benz USA or Daimler's contacts, meaning selling products, nothing, okay? So that's why this has to be, if you're gonna get jurisdiction, a general jurisdiction case and not a specific jurisdiction case. So why does the court ultimately conclude that there is no personal jurisdiction over Daimler in this case? Please.
Because they said Daimler isn't at home in California, because they don't, let's see, they're not incorporated in California or have a principal place of business there. They just don't have enough minimum contacts to be considered at home in California.
Very good. So we know that they're not amenable to, meaning Daimler, a suit in California for injuries allegedly caused by a conflict in Argentina that took place again outside of the U.S. The court is applying the standard from Goodyear. In order to have general jurisdiction, the defendant, as she said, must essentially be at home in the state. All that means is your contacts are so substantial, you can be considered at home, right? You have so many contacts, not minimum, but you have a lot of contacts. It's almost like a second home to you, right? The court tells us specifically that Goodyear does not mean that there is general jurisdiction only where a corporation is incorporated or where their principal place of business is located. Here, as I stated earlier, neither Daimler or its subsidiary, Mercedes-Benz USA, is incorporated in California, nor do they have their principal place of business in California. The court says that even if we assume that Mercedes-Benz USA actions in California can be imputed to Daimler under that agency theory, even if we assume that, they still said Daimler's contacts, and this is one of the most controversial part of the case, it is too slim in comparison to its nationwide sales. So I'm going to say that again because this is what a lot of scholars argue over. They said Daimler's contacts in California are slim in comparison to its entire nationwide sales, and because they are slim, it's not enough to render them at home in the state. So essentially, what your facts reveal is that Daimler's activities were essentially 2.4%, their contacts in California of their entire nationwide business. They're like, it's just 2.4% They're not at home there. But so the controversy with this case is a lot of people that are anti-big business are saying, yeah, it might be 2.4% of their, multi-billion-dollar business. Like, there's still significant revenue going to the state of California, and California should be able to adjudicate any claims dealing with their residents. Even if it's 2.4% of their entire corporation, it's millions of dollars. Other people say, no, the court was right in this case because, if you don't want a situation where these mega, corporations, international corporations, are subject to jurisdiction essentially in every state, even if it's 2% of their total sales, in the U.S. automatically. So they're saying, every state they have a little bit of sales, a percentage of their sales, they're subject to general jurisdiction. So this decision is very pro big business, right? Pro corporation. They're saying, it's 2.4%. That's not enough to say you're essentially at home in the state. Do you see the controversy there? Makes a big difference. And so, if you look at the second paragraph on page 141 of your text, the court says, quote, in the second paragraph, page 141, if Daimler's California activities suffice to allow adjudication of this Argentina-rooted case in California, the same global reach would be presumably available in every other state in which MB USA sales are sizable. Such exorbitant exercises of all-purpose jurisdiction would scarcely permit out-of-state defendants to, quote, structure their primary conduct with some minimum assurance as to where the conduct will and will not render them liable to a suit. So basically what the court is saying in that statement is that, expanding general jurisdiction to the point where a parent company may be subject to personal jurisdiction in a state which it has a subsidiary, or in every state in which a subsidiary has a large number of sales, is just too much. They're saying that's too broad of an interpretation and application of general jurisdiction because, again, that big company would be subject to jurisdiction essentially almost in every state. And so we know that Justice Sotomayor is the only justice, because it was a unanimous decision, that writes a concurring opinion. Do either Attorney Belanki or Jardigan recall what she was saying, what point Sotomayor was saying? Because she was the only one that filed a concurring opinion, and there's no dissent in this case.
She said she agreed with the conclusion, but did not agree with the logic that the court took to reach the conclusion. The court said that it's not Daimler's contact with California. It's not that the Daimler's contact with California are too few, but that its contact with other forums are too many. Essentially saying that the court, Daimler's too big for general jurisdiction.
Excellent. Yes. Does anybody agree? Great job with Dr. Sotomayor. With Justice Sotomayor's stance? Yes. You, Elizabeth, a couple of people. Anyone have thoughts on the case in general? Do you think it was ruled correctly? Jessica.
I just think this case is extremely confusing because there's too much going on. There's too many parties involved, and that's one of the reasons why they probably ruled the way they did, because there's too many parties to even keep track of.
This is nothing compared to like the number of parties in this case. Like outside these law school walls, you can have like 11. I mean, this is really actually small, honestly. Yes, sir. I'm sorry, I don't have the chart today.
What would be like a substantial contact with 10%? Like, I mean.
Right, and that's the other big argument. Like, what percentage? Like, there's no, and it's very subjective. I'm so glad you said that. Tell me your last name. Yeah, so what is the bar then? And why didn't they establish what that criteria is? 25% or more, 15% or more. So can you see, based on this case, as he did a great job highlighting, the inconsistent application of the law with this case, depending on what that judge's perception is of what percentage is enough. That was excellent. Yes?
I like Justice Sotomayor's concurrence because I feel like it was simpler. Like, she basically was like, there's a better forum for this, and we should do it in the best possible forum that's best for the plaintiff and also for the defendant. So, and I kind of like in Stevens, the next case talks about like, the court's just making this really complex argument that
they don't even
simply
need to do it.
Yeah.
When we get to Burnham, can you mention Stevens? Because I highlight him saying that. I love what he says in Burnham.
Yeah.
Excellent job. All right, let's go ahead and knock out Burnham. I like this case because it's spicy. All right, so I'm going to do the facts. Burnham, Mr. Burnham and Mrs. Burnham live in New York. New Jersey. And then they separate, unfortunately. Miss Burnham takes the kids and moves them all the way to California. Yikes. Mr. Burnham files a divorce action in New Jersey, but does not serve Mrs. Burnham in New Jersey or California. And he doesn't file on grounds of irreconcilable differences, as they had allegedly agreed. So they agreed, this isn't working, we're separated, we're going to file for divorce and just say the cause is irreconcilable differences. Well, Mr. Burnham got savvy and basically switched out on her at the last minute. He files for the divorce on the grounds of desertion, right? You deserted the marriage, you abandoned us. And so Miss Burnham isn't happy with this, so she's like, screw you, we had an agreement, I'm going to file my own divorce action in California, and serves Mr. Burnham while he's in California. Any idea why this even matters? Why do they care? Yes.
Does it affect the settlement and the custody and such?
Absolutely. Remember, different state laws have different rules and regulations. And so the Burnhams cared because of one thing, which is money. Mr. Burnham doesn't want to pay alimony or child support, which he'll have to do if he files in New Jersey based on irreconcilable differences. But at the time of the lawsuit, if he files for divorce in New Jersey based on desertion or adultery, wow. And it's like literally on airplane mode. If he files for divorce in New Jersey based on desertion or adultery, he doesn't have to pay alimony or child support, right? So that's why he filed the way he did. Does this make him a creep, or is he just like, screw her, she can afford to take care of the kids? Like,
He sucks.
Elizabeth.
Well, it depends on why he didn't want to, quote, pay child support, because the child support system is also messed up, and they can, like, really make it difficult for a person to even live. So maybe he wanted to pay child support, like, as an agreement between them two and just not involve the state.
Would you trust him after they had agreed of what they were doing?
No, but I'm
and
just
then you
saying,
said-
like,
I know, I'm just messing with you. All right, so we're kind of split on whether this guy's a creep or not, but we're just going to move on. So we know the controversy in this case is that Mrs. Burnham serves him, the dad, while he's physically present in California. Why is he even in California? Well, he's the dad. He's there to pick up his kids, right? He's visiting his kids. So Mr. Burnham's argument is like, wait a minute. He's saying that, if you look at the two-part test or three-part test from International Shoe and apply it to this case, he said, remember that famous language in Schaefer that all state court exercise of personal jurisdiction must apply minimum contacts, right? So he says, look, there's no personal jurisdiction. The state of California doesn't have any personal jurisdiction over me because I don't have any minimum contacts here. I just came here to see my kids and get out. Like, I don't have anything to do with the state. So what does the California court decide, Attorney Jarnigan?
That California has personal jurisdiction over him because the requisite minimum contacts were satisfied by his physical presence in the state.
In the state. So when you hear satisfied by his physical presence in the state, what comes to mind? What warms your heart from the first week of classes? In personam jurisdiction. What was our first case? You remember the name, anybody? Pennoyer. Remember, presence alone was enough. We spent a whole week just establishing, based on the Fifth Amendment Equal Protection Clause and the 14th Amendment, that each state sovereignty, has jurisdiction or sovereignty over residents or people within the boundaries of their state. That was Pennoyer. So this is kind of a challenge to Pennoyer. Is that still good law? Is presence alone enough? If I get caught driving through Indiana and served process to defend myself in Indiana, is that enough? Because you got to keep in mind, there is a certain level of unfairness argument that you can make that, look, I don't have any contacts here. The only way I can see my kids is if I come to New Jersey, right, to see them. Or is it North Carolina? I keep mixing the states up. But if I come to that state to see them, so I don't think it's fair that in order to see my kids, I have to subject myself to possibly being subject to jurisdiction in that state, okay? And so Burnham, unfortunately, is another one of these count the vote cases like we saw in Asahi, which annoy me. I like the unanimous decisions like we just saw. So part one of Scalia's opinion is the first thing I'd like to focus on. How many justices agree with Scalia? How many agree? Yeah, so 3 agree with him. Excellent. So there's 4 total. Those champions of justice are Scalia, Rehnquist, Kennedy, and Justice White. The justices can't even agree on the facts in this case, which shows you how the court functions at times. So we know it's just going to get uglier than Asahi. At least in Asahi they agree on the facts, but here they don't. So at least the justices agree on the result, but not the rationale for the result, right? The theoretical underpinning. So yes, we agree. We all agree on whether or not there should be personal jurisdiction, but not on the reasons as to why. Part 2 goes on to analyze the relevant case, and they say that the issue here is whether service of process within a forum is enough, because that's essentially what happened. He was served process in California to establish personal jurisdiction, or do you have to assert minimum contacts under Pennoyer as a form of personal jurisdiction? Is that okay? Or do you have to have minimum contacts as well? So what does Scalia say? I love starting with Scalia. Any volunteers? What does Scalia say? Yes.
It's just like the way that it's always been done, so it should stay that way.
Yeah, he's like, look, we've been doing this since the years of Pennoyer. He refers to it as tag jurisdiction, tagging the person, kind of like tag you're it. So why are we even having this conversation? It's settled law. He says the English did it, we did it, it's a tradition, so it must be constitutional. Pennoyer is still alive and well, right? He says most people thought in 1868 that physical presence permitted personal jurisdiction, so let's just move on. He says if it was good enough to be good law in 1868, it's not like the Constitution has changed since then. So Scalia basically says the service of process that is done in the foreign state, which here is California, is a sufficient basis to grant personal jurisdiction. Scalia goes on to mention Schaefer in his opinion, which I think our attorney upstairs in the back row was referencing. What does he say about Schaefer? Are you okay doing that?
Oh, yeah,
Sorry, I just don't have my seating chart. They tell me your last name so I don't say, hey, you.
Webb.
Okay, Attorney Webb.
Yeah, so are you talking about Justice Stevens? Because that's what you.
Oh, I know. I meant what does Scalia say about Schaefer in section 2D?
Oh, okay.
If that's not what you were referencing, you're not on today. I can move on.
He says basically that like the strongest argument that the plaintiff had was in Schaefer, but that Schaefer only applies to property being related to the case, so it was like basically inappropriately used.
Yeah, so he's like, look, you're trying to apply Schaefer. That's a quasi-in rem case. We're back at it again, trying to apply it to every aspect of personal jurisdiction. He says it's largely a distinction without difference. I love that. That's one of my favorite things. He says it's akin to saying, well, that guy's name was Schaefer and this one is Burnham. So he's like, look, Scalia doesn't expressly say he'd overrule Schaefer per se in this particular case, but concludes that he will not extend it to physical presence, meaning he's not going to extend the requirement of minimum contacts if you want to serve someone for tag jurisdiction. If you want to serve someone notice of a lawsuit in the state, he's like, I'm not going to require them to have minimum contacts as well. I'm not going to do it. Scalia gets 3 justices total, including himself. Scalia, Rehnquist, and Kennedy. White doesn't join in this part, which is somewhat strange, and just never responds at all to Schaefer. That was kind of an oddball thing, why White doesn't respond at all. But Brennan, what is Justice Brennan say, Attorney Jarnigan?
That minimum contacts must be met, and that being there for 3 days isn't enough time to purposely avail.
Yeah, so I think it's kind of interesting what he's saying. He's saying, look, well, I'm going to talk about Scalia's response to Brennan, because I think that's a little bit more exciting. So Scalia says, look, Brennan, Like, have you really thought this through? The benefits are unequal. He said 3 days of police service doesn't equate to division of all your property. So yeah, he was there 3 days visiting his kids, but so for 3 days, if he needed the police officers or emergency services, he could call. He's like, but if benefits matter, why does it matter that you were served while you're in the forum? Why isn't visitation enough then, if you need benefits? And he's like, and how much time do you physically have to be in the state of California to say that you benefited from the state? 15 minutes, 10 minutes? Can I drive? If I drive across the river to Indiana to meet my significant other to pick up our child, am I there long enough to where I benefited from the state of Indiana, whatever they have to offer, their protection? So he's being sarcastic, but he's making some very strong counterpoints, meaning what is enough to establish that? And so Scalia's opinion, again, he only has 4 votes, so keep that in mind. But his slam on Brennan and on the minimum contacts test as a whole, it's pretty powerful. So before we end with Stephen's opinion, how many justices vote that personal jurisdiction is proper over Burnham? Remember I mentioned earlier, we know all of them, meaning it was a unanimous decision. In the portion of the opinion that's omitted from your book, they all affirm that California courts exercise personal jurisdiction over the defendant. So Stephen's point, in terms of, I think will help you understand this concurrence, he says, look, which is what you were referencing earlier. He's like, Justice Stevens says, we all agree there's personal jurisdiction, but here we go again. We're doing the same exact thing we did in Schaefer. He said personal jurisdiction is proper regardless, as I said in Schaefer, on whether minimum contacts rules the day or whether we stick with our traditional stance. He said all the Burnhams care about is who wins, right? He said we've already agreed on that. We should wait another day to resolve the mega dispute as to whether minimum contacts are necessary for all assertions of personal jurisdiction. He said today is not the day to address this. We've already decided what the correct outcome is. He's basically repeating what he said in, again, Asahi and Schaefer. In other words, the Supreme Court unanimously upholds personal jurisdiction over the defendant. They just disagree on the specifics. And so what the takeaway is from the Burnham case is that, yes, Pennoyer is alive and well. It's still good law. So tag jurisdiction, which is how it would be referenced on the exam, is another way to establish personal jurisdiction over a non-resident defendant. So we've learned a lot. We've learned that you can establish personal jurisdiction over a non-resident defendant through in-rem jurisdiction, quasi-in-rem jurisdiction, specific jurisdiction, general jurisdiction, and now we've got our last one. There's no more. We're like really done. Tag jurisdiction. So if any of those 5 types of jurisdiction apply, then doggone it, you're coming to Kentucky to defend yourself. So when you're out in the real world and you're talking to your client, you're going to figure out which one of these 5 apply so that you can file the case in the state where your client wants you to file it. Which of these 5 ways can you make the non-resident defendant leave his home or her home and come and defend themselves? This is great. This is clear. So can I tell you before I let you go how my teacher taught me? He never explained that all those things go together. That's why I was having the meltdown in the atrium, because I'm like, sure, I know what specific jurisdiction is. I know what general is, but I didn't know if you needed all of them, or like he just never told us. He's like, you're supposed to figure that out. I'm like, you're the lawyer, creep. You tell me. I just was like, this guy's a jerk. And so it makes me feel good to be like, oh, I'm not a jerk. And more important, I want you to learn this because no matter what area of practice you go in, if you want to file the case in civil court, if it's not criminal, you have to know how to do this. You cannot file your case if you don't know whether or not it can be done in that state. Because they're going to challenge you, as we'll talk about later in the semester, and say, Attorney Malanki, I just submitted a motion for dismissal for lack of personal jurisdiction. My client doesn't have minimum contacts with Kentucky. He's not coming there for no suit. But that's how it works. And so you have to know how to build a strong case so that your case doesn't get thrown out of court. All right, I'll see everyone tomorrow.
So if you're a corporation and 10% of your you're hesitant to impose jurisdiction,
What's today?
you want to see your kids pass stay. No problem.
There's like no one behind me, and there's a voice here. I'm like, am I? Oh, so before you go, sorry, I didn't know she had a question.
Did anybody find some keys out in the lobby on a table, like my life of keys? Darn, okay.
So if you see keys anywhere in the law school, if you can take them to the LRC as you're walking, she would be very grateful.
I would be very grateful. Great, and if you happen to be in one of my sections, you might get extra credit.
Let's find these keys.
Thank you.
No, I just someone was behind me.
But yeah, that one case, it's like 8 or 10 days.
Okay, so we need to review these cases because this shit right here, a lot of it went over my head.
I'd appreciate
So
that.
what? I got.
Yeah, it's just long and dense.
Yeah, Daimler. What the
Yeah, I know.
It is all work. Oh, right, yeah, it just goes, and there's so, yeah, they spend so much time doing the reasoning. But then that's the other thing, they're like,
look, he's an agent.
they don't just
So you
rush all
they're an agent, so we can
part
hold
of
him
it,
accountable for his. Basically, it's like
and
those are your kids. You're responsible for them.
the stream of commerce.
like I haven't.
Cause like I guess I do my best to I don't pay attention to all those details. Like I don't avoid. Like I don't. Like I am important, but I guess it is. Oh, here, Demetrius. I'm hungry.
But that one's like, oh no, after this Piper case,